see the whole strategy here by the prosecution.
Their strategy is to put you behind bars over a crime that you committed, for which there is evidence. So you can smile all you want and point out the fact that you figured out their strategy, but looks to me like their strategy works because they've got the evidence to back up their claims, as opposed to you, sir. I'm still trying to decide whether I want to do a video on this or not, but I don't know. I guess we'll just watch a few of the videos and decide from there. The topic that is so fucked up in my head right now is this Darrell Brooks case, okay? If you guys know who Darrell Brooks is the perpetrator of the Waukesha Christmas Parade massacre, or rather he's being accused of that, and his entire thing is that he has to prove that that was not him. My issue here is that there is overwhelming evidence that yes, it was him. And it's just insane to watch someone who is not fully understanding the decorum that is needed to be in a court of law, essentially, in our country, because everyone is entitled to a jury, or I mean a trial by jury. And this is just, honestly, my brain becomes fuzz anytime he begins to go on his tirades. I just feel like I'm in a swirl of PTSD when I'm listening to this man. Because if any of you have dealt with someone like this, they just assume that no matter what, you're wrong and they're correct. So this poor judge the entire time is trying to make sure there's no ifs, ands, or buts about whether or not this was a fair trial, so that when he does finally get sentenced, convicted, thrown into jail or whatever, he has no right to appeal this. I think that is very clear here. Anytime that I see anyone saying, oh, the judge is letting this man just walk all over her, that makes me so angry, because you guys don't understand the magnitude of this case. He keeps trying to derail the conversation, keeps delaying the bringing out of his witnesses, all for that end, so that he can delay the inevitable, which is him getting sentenced and going to jail. It's like, okay. These are just my thoughts from what I have already seen. There's a lot of clips that I have not seen, and we're gonna watch them together. There is this one where he starts raging at the judge. I think this is from a day ago. So this is literally the last stuff right before the weekend. And I do remember watching some of that testimony and some of that stuff on Friday, and it was too much. I actually had to stop watching. And what I decided was the only reason that I would even watch any of this shit is if I were to do a video on it. Because otherwise, I'm just putting myself through shit. Okay. This poor judge. Okay, so the title of this one, and we're going by, there's multiple channels I'm going to be using for this video. It's going to be the Live Fox channel and some Law and Crime. So I'm going to be putting all of the sources down below. And let's just fucking go, because the title of this is Darrell Brooks, Furious When State Reveals He's a Registered Sex Offender.
All right, sir, I'm going to let you make an offer of proof as to why you believe the photographs and the questioning about contact after the alleged incident is relevant.
It's relevant because these were sent by the witness.
It assumes a fact, not an evidence, but
You
what
want
is,
the letter
hold
too?
hold on. Tell me the basis you believe there's been communication and why you believe it's relevant to her testimony.
It's relevant because it was testified to her first time testifying, and then also by was the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid,
I can't wait for him to just be sentenced already. It's just the way that he conducts himself in front of the judge. He's so disrespectful to her. She's trying to be nice. She's trying to give him the courtesy to show and explain why something's going on. And he's over here mocking the witness, first of all, mocking other people that have testified. And it's like, this just shows how little you care about other people. It just shows. And just look at how he talks to her. It's so fucking rude.
was the last guy, Guth, that he was told that the witness was supposed to be so deeply afraid of me and all this type of stuff. So if you're so deeply afraid and worried about somebody and this and that, why would you sneak and have
Do you want
contact?
to open up the door to the other act's evidence of
That's
you
not
use-
opening.
No.
That's not
Hear me
opening the
out.
door.
Hear me out. Oh, yes, it does.
No, it doesn't.
These witnesses have been incredibly careful to abide by my rulings. Sometimes in a court of law, when there are pretrial rulings, the testimony of a witness needs to be said in such a way not to run afoul of that. This witness, Detective Guth, I believe Detective Casey and others, Corey Runkle, and even Nicholas Kirby yesterday, this court has all had to stop them so that they didn't run afoul, or they've stopped themselves so that they didn't run afoul of the court's pretrial ruling on other acts evidence between you and this witness. And I have been very, very careful to make sure that doesn't come in. But if you keep questioning her about whether she's afraid or not, or why she wouldn't have contact.
What's wild is that this is a person he abused. This is a person that was under his thumb for a very long time. She has to pull out the strength to testify here. And just imagine your abuser is the person who is throwing this line of questioning at you, and your only line of defense is this judge. And she's doing an amazing job of running interference between this man who is clearly just out of his depth, trying to lawyer himself into showing that this isn't okay, that they can't bring this in, but he's the one who keeps provoking the witness into answering questions that will further open that up and hurt him. So I just find it wild that she's trying to tell him, look, you're shooting yourself in the foot here by going down this line of questioning. And he's like, no, I'm going to ask whatever I want. Okay. We're going to get to that point with you, and we're going to throw away the key, and you're not going to get an appeal. That's why I really appreciate this judge. She's not letting him get to her. She's dealt with people like this before. And she's like, you know what? We're just going to do everything in a timely fashion. We get there when we get there, but nothing is being delayed. I'm not holding you in contempt. You can go in the other room over there and have a tantrum. That's fine. But we aren't delaying shit. I respect her.
Or not.
Let's go back a little bit.
But if you keep questioning her about whether she's afraid or not, or
I
why she
didn't
wouldn't
question her
have
about that.
contact or not,
I didn't
you are
question her about
opening
that.
the door to that testimony. All of
How
my
does-
rulings have
how
been
does-
made to prevent
how
what
does
could be
pictures
seen
show-
as prejudicial evidence. The standard's not prejudicial. The standard's whether it's unfairly prejudicial. But you can open the door to that, sir.
It's unfairly prejudicial.
It's unfairly prejudicial, or could be, to you. And she's trying to help you here. And you're trying to fight her. That is why I know for a fact this man is not okay. And I know for a fact that he doesn't want to look in the face the fact that he committed those 6 murders and injured all of those people. Y'all saw his opening statement. Y'all saw it. And if you didn't, we're going to play it after this one.
Prejudicial that I have a document stating that November 20th never even happened, but yet and still the witness can get on the stand and lie on the stand.
Have you turned that document over to the state?
Come on, man. Y'all know that's not right.
Oh, y'all know that's not right, even though she's telling you and asking you, where is that document? Because if it exists, it can help you. Submit it. Where is it? And he's like, it's not fair. It's not fair. I don't have that paper. So did you make it up? Did it never exist? She is telling you, if you have it, submit it and we'll put it in. And he's just like, bro.
Y'all know that's not right.
Then you need to immediately turn it over to the state right now. It may become relevant, but no one has seen it. When did you receive the document? Hold on. When did you? I'm having you make an offer. But when did you receive the document?
Okay, but I just want to state for the record, Your Honor, that's kind of biased because the state did the same thing yesterday with creating an exhibit right on the fly. They did.
I don't think he knows the legal process, and I think that's what makes all of this even more frustrating for everyone, because they're like, I went to school for like 8, 10, 12 years, and I know the ins and outs of this law and how to put shit into the system, and you're telling me that I did shit wrong? Mister, I suddenly have a law degree? Ugh, bro.
Didn't even exist that I didn't have. But
that's not true. That's a misstatement of the evidence.
That is true.
No.
She said it herself.
No. Marking an exhibit is not creating an exhibit.
No, not marking an exhibit. She said.
We're not going to go down a tangent, sir.
All right,
I'm going to focus on this, and I'm going to give you the
fair.
opportunity to make a record.
It's not
all right?
fair.
It's not fair.
When did you receive
I feel bad for whoever has to argue with this man. Because at the end of the day, nothing matters. They're always going to be wrong, and he's always going to be right.
this document that you claim was sent by this witness?
It is not claim, it's for a fact.
Sir, it hasn't been established yet. I need to make a record.
How is it a fact if you can't show the proof? That's the thing. That's the thing, bro. That's all she's trying to get to. That's all.
Y'all want
I
the
want
letter?
to see
Y'all
the
want the
letter.
envelope? What?
I want to see the letter.
Okay, so I gotta.
And I wanna know when you received it.
I gotta bring that in. Every time, this is what I don't get. Every time I'm presenting something that needs to be made for the record and placed in the evidence, it's a problem.
It's a problem because you don't know the process. And I've seen it happen multiple times. When they go to put something into evidence, they do it through the proper channels. They're like, okay, admitting exhibit, whatever it's called, into evidence, permission to publish. It goes like that. He is over here just expecting people to believe him by his word and no evidence, no exhibits, no nothing. Like, sir, this ain't how this works. This ain't no Wendy's. Like,
but the state can do it, no problem.
It's not, sir. There are proper procedures, and
Okay,
I want
well,
you to
that
make
was the
a
proper
record.
procedure.
If you don't make a record,
So
then
what?
I can't make a ruling.
It threw people off a loop. They weren't ready for it. They scared of it. That's what it is. Come on, man.
Mr. Brooks.
Come on, man. Stop.
When you
Stop
aren't
Stop
even
it.
letting me.
this is so aggravating, bro. Just I feel triggered watching this. I truly do. Okay.
Public
Ask
servant,
the
Your Honor.
questions.
I respect your courtroom. I
You
respect
do.
you. You're a public servant, though. Your job is to be the referee. Is it or is it not? You stated so yourself on record that your job is being the umpire.
And then he doesn't even let her talk. That's like, what are you doing? You expect her to be on your side, and then you're disrespecting her in her courtroom, not allowing her to have a conversation with you. It's literally just you talking at her. And when she tries to explain to you in plain words, in a way that may benefit you, you're still acting like she's your enemy. She's literally there to make sure that you have a fair trial. And you're just shitting on it. This is what you get. I fucking hope they throw the entire book at you. I hope they lock the door, throw away the key, and you're in there for 6 consecutive life terms, because this is some bullshit.
Your Honor, can I ask Ms. Patterson to be excused?
Yes, you can be excused. My apologies.
My apologies too, but it needs to be some truth.
My apologies too. You're not apologizing. You're the reason this is all happening. To then be like, oh yeah, I also apologize. You're the cause. Shut the fuck up.
Especially when we're talking about stuff that didn't even happen, but they're allowed to get on the stand and say that it happened when they know it didn't happen.
So I'm going to make a record about what
This
he's
is
referring
ridiculous,
to
man.
in count 77. Okay. The
And what happened?
I'm sorry, I don't mean to laugh because this is very serious. But the behavior that he's displaying, he's just acting like a child. Like, oh, this isn't fair. You don't know that this happened when you know for a fact. How about we talk like adults here? And you can say whether it happened or not. Oh, and it's your turn. Stop interrupting everybody and trying to control the narrative. That is what's going to make you lose. And you know what? I hope you do lose, motherfucker.
To that paper because it was on the table. Then when I
Mr.
come
Brooks,
back in,
I
it's
need to
nowhere
make
be
a
found.
record of a variety of
So who
things.
took my paper?
And you keep interrupting me repeatedly today. I have shown an abundance of patience this morning. I've warned you repeatedly about being removed from the courtroom. And then every time I try to get into it, you, meaning an explanation and make a record, you interrupt, you attempt to divert everyone from what is being done this very second.
I didn't attempt to do anything.
Yes, you.
I didn't attempt to do anything. Anytime that he interjects, like, none of that is helping you, bro. You look like an asshole. And you are being an asshole. Like, shit. My biggest thing here is I understand that people have the right to represent themselves. And that's fine. But that does not mean that you get to make a travesty out of this entire trial. Just because you have the reins and you can represent yourself. That doesn't mean that you're in control of anything. He is having the time of his life. Because he knows. He's fucked. The state has so much evidence in the contrary of his stance where he's like, oh, I'm not Darrell Brooks. That was not me. I don't consent to being called by that name. Like, it's fine that you have nothing to lose at this point, but you're wasting everyone's time. It's fucking gross.
You do it repeatedly, sir.
Whatever.
So you're doing it once again.
Whatever. Just make your record.
Whatever.
The document that Mr. Brooks wanted to show Detective Guth and this witness was a letter sent from the state of Wisconsin to the court regarding count 77. The state sought to dismiss that count, and they have prosecutorial discretion, and I granted the request that the charge be dismissed.
Why was the charge dismissed?
And that's, I can't answer. It was dismissed because the request was made, sir. They don't need a reason. There's an abundance of case law about prosecutorial discretion. And they chose not to pursue that. My guess
Your
is
Honor,
maybe
with
to
all respect.
simplify things and to keep this tidy. I don't know. You know what? I'll indulge you. Attorney Opper, would you like to provide a basis?
Wow. That whole part right there where she was like, listen, you know what? I don't fucking know why. But let's fucking ask him. Hey, you got the answer? You want to answer this for him since he's so fucking concerned about why this charge was dropped? Like, dude. in the end, it's to your benefit. So I don't see why the fuck you care.
For why the state sought dismissal of that charge prior to the start of this trial.
Yes, Your Honor, because as Ms. Patterson just testified a short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Your Honor, I object to that. What does the letter read?
So would you rather they fucking charged you for battering her? They just didn't want to throw it in there because while there were photographs, they just didn't want to confuse the entire situation, because what happened was, yes, she did claim that she was hurt, but she didn't want them to press charges. Or at least that's what it seems like. Let me go back and listen again, because that's what I interpreted.
A short while ago, she did not have any visible marks or injuries from that event. And we did have the photographs of her injuries. We did not want to confuse the record as to whether or not there was a battery that occurred on November 20th.
Okay, so that's why they did not want to include the photographs. Because while they did exist, they dropped the charges because there wasn't, I guess, sufficient injury to what happened to her personally on that day. But that's not to say that there isn't a history of abuse there. And he's lucky that they were like, you know what, let's not even confuse the case more than it needs to be. We're just going to remove this part here and we'll just go on. But he just keeps poking at it. And I don't understand why. Like, is it like some personal vendetta that he has against the person that he abused for years, which is Erica, his ex, this witness? I don't understand. I don't get what he's trying to do.
Your Honor, I object to that. What does the letter read?
You have the letter. You showed it to me, sir.
And I've been trying to find it ever since I came back in here. And now all of a sudden I can't.
And now
find
you're impugning, though, like somehow you're impugning the integrity of this
Okay, suddenly you don't have it? What are you talking about?
court,
No, I'm
the
not.
bailiffs of this state. You're accusing, frankly, everyone
Did I
of
point
moving
the
your
finger?
papers.
Did I point the finger at anyone? Did I say anyone did anything?
Not directly, but indirectly you did,
So
sir.
how can you make the assumption that I'm saying?
Can
that
I
I'm
please
pointing to
make the
someone?
record without
Yes,
you interrupting
yes, you may.
me?
Yes, you may. I apologize.
I appreciate that, thank you. But you made repeated comments, sir, about I can't find my documents, I don't know what happened, things of that nature. When you came back out, you took multiple minutes before you even asked your first question of Ms. Patterson. And if I need to, I'll have a bailiff put on the record that no one touched your table.
Your Honor, did I say anyone?
Okay, no one gives a fuck about that. But did I say? No, you're fucking implying it. Earlier, he was like, yo, but where did my paper go? It was right here a second ago. That implies that someone stole it. I can't fucking stand this motherfucker. Like, I'm giving myself hives. Okay.
Wouldn't touch my table. I didn't
You
say you.
implied it, sir.
But did I say that?
You
never
stated
said.
it implicitly.
I never asked the bailiffs, hey, did any one of you touch my table? I never said that to
Okay.
them. I just said
I can't with this loop right here. So we can move on to this one. So he, for some reason, doesn't seem to think that this was an attack. But I don't even want to watch that because I'm going to get even more mad. I think that what we can do is
Go ahead, Clay.
watch him getting really angry. And then we're going to look at his opening statement.
Your next witness.
And when we get to the next break, I have something to discuss outside of the presence of the jury. If that pleases the court.
Do you want to do that now or after your next
We
witness?
can.
All right, I'll address a legal issue, and we'll bring the jury back in when we're ready. I'll rise for the jury, please.
I'll be honest, imagine being on this jury, bro. The amount of times you have to go in and out of this courtroom is wild. This is so unorganized. And honestly, it's not anyone else's fault because I've seen trials where it goes smoothly because you have two teams of two lawyers or many lawyers, but there's two teams and they're very organized and timely with everything that's going to happen. So they say, okay, we're going to do 2 hours for this witness, 1 hour for this witness. We break for lunch and then whatever. There is no structure to anything with him. But it's because he's not a lawyer. He doesn't do this. So just imagine being on this jury. You walk in, 5 minutes. Oh, we gotta get up. Time to go. 5 minutes later, go back in. 10 minutes later, get back out. Go back in. This is fucking wild, dude. Like, what bothers me a lot here is that I obviously am a very empathetic person. I have empathy for people that grew up like Darrell Brooks, who probably were just allowed to do whatever and had no structure in their lives. But this is fucking gross negligence of parents, of the community. Like, this man has been acting like this for his entire life. And his extreme anger just exudes him in waves. Like, he is scary. I'm surprised that nothing happened before this. And the whole catalyst for this even happening was him getting angry with his ex that he abused. Like, you killed these 6 people over something personal. You shouldn't be on the streets.
Everyone can have a seat, and then we'll just wait for the door to close. Go ahead, Mr. Brooks.
I'm curious.
I'm curious about how many times he's actually let it slide by where he's allowed to be called Mr. Brooks. And he knows that he is Mr. Brooks. But every other time, it's like, I don't consent to being called that name. That's your name, bro. Just let it go.
Some of these, judging by the reports, how are some of these answers allowed to pass when they're coming straight from reports made by the people on the stand? Very curious.
I don't understand your question. I'm not sure what you're asking me.
What I'm asking is, reading from the report that the people on the stand are giving, the report that they gave to law enforcement.
If you're asking me whether there's a mechanism in the rules of evidence and how to establish that before the jury, the answer to that is yes. If you're asking me how you do that, I'm not going to answer that.
I didn't ask how. to be blunt, which I've been since the beginning of this trial, obviously,
Obviously.
I see the whole strategy here by the prosecution.
Their strategy is to put you behind bars over a crime that you committed, for which there is evidence. So you can smile all you want and point out the fact that you figured out their strategy, but looks to me like their strategy works because they've got the evidence to back up their claims as opposed to you, sir.
I see right through it. Don't have any cross-examination, mainly because you've already schooled the people getting on the stand on how to answer certain things.
Well, that is completely speculative on your part without
It's
any
obvious.
basis in law or
It's
fact.
obvious.
Sir, you could ask questions that establish that. You can ask them if they've met with anyone. You haven't done that. So for you to say that right now is without basis. If you want to,
It's clear.
if you are looking,
I hate when people do stuff like that. Like they say, look, it's clear, but without presenting any evidence. Like what are you talking about? It's clear. Are you the only one that's seeing it? Am I blind or am I dumb? Like, do I need a special set of eyes like yours in order to see it? Because I don't see it.
looking to elicit what they said in the report, there is a way under the rules of evidence based upon the way the witnesses have answered to clarify that. But that requires you to call certain witnesses. I'm not going to give you any
I don't
more
think I have
legal
to- I don't
advice
think I have
further
to-
than that.
I don't think I have to
So
call any other witnesses that's
if
not
you're
on the
asking me to
stand.
strike their testimony based on your
I didn't say
perceived,
anything
then that's
about that.
all right. Then I'm going to bring the jury back out. And you're going to call your next witness. So I'm
So
not
is you-
hearing a request from you at this time. You said you wanted to raise a legal issue. What's the legal issue?
The legal issue is how is the state allowed to coach the
You're
people getting on the
assuming they
stand?
spoke to them and coached them.
It's obvious. I'm not stupid.
What the fuck, bro? All they do is ask questions. If you wanted to, you could have your notepad ready and take down notes of questions that you want to ask according to what they're asking. But I will see you doing that. But then everybody else is at fault. Ugh, God.
Well, I disagree with that, sir. Again, you could ask
All of a
questions to
sudden,
lay a foundation
all of a sudden, the
with
state
these
don't got.
witnesses.
All of a sudden, for the first time in trial, all of a sudden now they don't got no cross. That's clearly a rush to try to get through the case. Hurry up. We just gonna let these people go.
Well, this
and
is
not-
our
Oh, you're mad. You're mad about that. You're mad that we're gonna finish the trial and get to the point. That's what you're mad about. You're not mad that they're not asking any questions. They already got all the answers that they needed, boo-boo, and now you're mad because the trial is progressing and your strategy is foiling apart. I see you. I see you.
argument.
Come on, man.
This is argument on your part,
I
sir.
see
It
through
is
it.
pure
I
commentary
just
at
want
this
that on the
point.
record. I see through it.
No one
And your
cares.
Nice try,
see-through
but I see through it.
has absolutely no basis in
But
fact.
I know that's what's being done.
You
Come
could
on, man.
ask
I'm-
these questions. You could
Come on,
ask.
man.
I'm going to commend this judge till the end of my days. Okay? This woman comes to work every single day knowing that her day's gonna be a whole mess. And she's still here. She's still doing her duty and making sure that he has a fair trial and that everything goes the way that it's supposed to. And all she deals with is whatever. Fucking comments from the peanut gallery all day. I could never, bro. That first day, I would have thrown my book at him from the judge's podium. This woman is a saint. And I know that it's to that end that, she wants there to be a seamless trial, no mistrial, No room for appeal. So when he finally does get sentenced and go to jail, that's it. I respect her for standing by her laurels. Every time she needs a break, she goes and she takes a break. But Jesus Christ, all of these people, please give them therapy after this.
These
Got the right
witnesses
one.
certain questions, and you're
far,
not.
I'm far from an idiot.
They're your witnesses, sir. If you believe.
So I'm gonna start asking every witness up here that they seem just to mysteriously now not have any cross for it. Have they been coached to answer the way they answer? Because
Well, you can't ask that, but you can ask them if they've met with anyone ahead of their testimony here today, which you've done with other witnesses.
I find it very funny that
Bro, you don't even listen to her. I find it very funny. I find it very funny. I find it very funny. I just want to hear myself talk. Shut the fuck up and listen.
these are their reports, and now all of a sudden you can. Oh, I saw the person in the car. Oh, but
Mr. Brooks,
I
this
saw
is
them
an
reach
attempt
for
by
something.
you
Oh,
to
I don't.
delay these
I don't recall
proceedings.
what they had on.
Mr. Brooks,
You can
there's
recall
no
seeing
purpose
somebody
for you
reach
saying
something
this
and
right
don't
now.
know what they had on. I find that
All right,
very.
I'm having the jury brought out. I'm instructing you to
Come on,
avoid
man.
the commentary when the jury comes out, or you will
I didn't
forfeit
say-
your right to be
I didn't say
present.
nothing.
Before we do that, there's an issue that we do need to take up potential as to a witness by the name of Abel Lescano. He has prior criminal history.
Thank you.
So as long as the jury's out, we should probably discuss that. I would like to provide the defendant and the court with a copy.
So that had
of
to be
the-
said. So it's the defendant.
That's not how it was said. I
That was how I
completely
said. You want to?
You're the defendant. You're literally the defendant. I don't understand what. I'm sorry. I should not be laughing at this. It's just fucking laughable at this point. Even this guy, sir in the corner, is having a hard time, just like I am. Because this is some bullshit.
Run the record back.
Mr. Brooks,
So I'm the only one. I got one. I
Mr.
got one
Brooks.
ear that work, and I heard that.
this
Come on,
is
man.
to benefit.
Bro. Literally, she's trying to say, like, this is to your benefit. The fuck?
One ear that work, and I heard that.
This
Come on,
is
man.
to benefit
man.
you so
No,
that
it's
you
not.
understand
Ain't none of
your
this to benefit
witness
me, so let's be
has
clear
a
about
prior
that.
record.
Your Honor, when I leave the table, I'm away from the courtroom and I have to elevate my voice. This is the
So she had to
alleged
elevate her
record of
voice
Abel
just for
Lescano.
that.
Wow. 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 She was literally coming around the table, and that was the word that was coming out of her mouth as she was going around the table. Like, every single thing in his mind is like a malicious thing. And I understand you feeling that way because you're the one who is on trial. It is your trial. This is about you. You need to separate yourself from this. But obviously that's not gonna happen. Like, if you're representing yourself, you can't do this. He just keeps like morphing back and forth between his counsel and himself, and it's confusing, and it's fucking annoying, frankly.
Stop talking.
Come on, man. Like, I don't know who y'all be thinking y'all fooling. I accept the value, return for value.
And he's still
It's,
talking.
documented.
One more interruption and you're going to be removed to the next courtroom.
That's what you want to do anyway.
It's not what I want to do. Do not interrupt Attorney Opper.
So can
Your
you
Honor,
tell,
I
can you
believe he
split-
has 7 prior criminal convictions via OWI 2nd from 1997, and OWI 3rd from 1997, and OWI 4th
Was that him slamming the table?
from 2003, criminal trespass to dwelling from 2006.
Right, I need to take a break. This man right now is having a stare down with me. It's very disrespectful. He pounded his fist. Frankly, it makes me scared. And we're
I'll be honest, I would also be scared. What the fuck? Okay, so this is the clip right after he has a fucking hissy fit, punches the table, and leaves. I think she returns from break, and this is what ensues.
I don't need no offer of proof.
I'll ask you a second time. Do you have an offer of proof to provide, sir?
We can go past all that. I don't need to ask them questions. It's too much of an issue. It's too much of a problem.
Mr. Brooks, I'm gonna ask you for a third time. Do you have an offer of proof
I
related
just
to
said
the
no. I just said no. I just said that.
All right, thank you. Then based upon there being no offer of proof, then
Yo, he's a fucking dick, bro. I can't stand that shit. She's over here trying to help you and you're just slamming shit, being a little bitch.
my decision stands. As to the
Bro, you're lucky they don't make bitches like me judges. Throw the whole book in your face. I'm sorry. I just can't.
continuation of the examination of Ms. Patterson, I would like an offer of proof as to what you believe her probative and relevant testimony will be from this point forward.
I mean, I don't know how she's going to answer the rest of the questions. There's not that many questions left. I was almost done.
Yeah, you would have been done quicker if you weren't trying to delay shit and extend it and make it even longer and torture this poor woman. The whole reason why this judge is asking you is, are there any more relevant questions, is so she can release this woman and let her go back home to her children. Like, you fucking piece of shit.
What topics generally were you going to question her about?
I guess I'll have to look in here because so much that happened since over the past hour and a half or so.
Bro.
I can tell you one thing. I don't intend to have too many more questions. I tell you that. I was almost finished.
I need an offer of proof as to what
She needs to know what you're gonna fucking ask.
you believe her testimony would be, meaning what topics? And are they topics that have not already been covered either through her direct examination from the state, your cross-examination, or already covered by your direct?
I don't remember her. What do you mean by related to her direct? Is that from the last time she testified?
From the first date that she testified and from today?
I don't
What
remember.
new topics
I
will
don't
you be?
remember everything she testified to the first time. It was 2 weeks ago.
Well,
Are you fucking kidding me, bro? So you're telling me that you're not, like, paying attention? I'm sorry. I'm so triggered by this, man. I can't.
Mr. Brooks, this is your opportunity to prevent relevant and probative evidence, but under 906.11, she's already been questioned now twice by you. So what new topics do you intend to question her about when she comes back on the witness stand?
What do you mean by new topics?
If you're just gonna go over the same old bullshit, she's gonna dismiss her and let her go home. That's the point, stupid.
Topics that you haven't already covered.
What, to pursuant to the police report or something? Is that what you're asking? I don't understand.
I'm asking you, I'll ask you once again, sir, give me an offer of proof as to what you believe your questioning will be as to Ms. Patterson going forward.
And you say it related to topics, right?
Yes.
You can just give me the topics, I think that's fair.
I wanted to ask questions about the police reports. That was the last few questions.
Bro,
That's
I
why
can't.
I'm saying it was only...
I can't do this. This is too circular. It's too fucking circular. Like, how many times do we have to go through this, bro? She already told you. She told you why she's asking these questions. And you're like, but why do you need to know that? But why? It's because you're wasting time.
Is it a statement that she wrote?
I don't know if it's a statement that she wrote in here. Possibly is.
Do you see a written statement with her signature
I
on
would
it?
have to go through all the paperwork.
Is there a written statement from Ms. Patterson?
No, Your Honor.
It's my understanding Detective Guth spoke to her on both occasions, is that right?
Yes, with Detective Barron with him on the first occasion. Detective Barron wrote that first report. Both interviews were also recorded.
Previously provided with discovery?
Absolutely.
What about the police report, sir, do you want to question her about, so I know with specificity?
looking at it now.
I'm losing my mind.
How many officers did reports? Because it seemed like it's more than just 2. At least from this paper.
Homie, if you don't...
I can maybe help and try and explain. I'll be able to show me what Mr. Brooks is referring to. I can maybe help and try and explain, but
Sure.
I don't know what he's talking about.
Bro, that's wild. You got the lawyer from the opposite team trying to help you out because you're so fucking stupid.
Mr. Brooks is referring to, I can maybe help and try and explain, but
Sure.
I don't know what he's talking about.
I can't find the first page to that, but whoever that officer is right there. I have to snatch it.
Had to snatch it. What are you talking about? He's taking it from your hand. Everything's wrong.
So I've got
Everything's wrong in his head. Like,
pages 2 and 3 out of 6 from Detective Barron's report under Waukesha Police Department incident number 21-047533. This is one of the 2 reports we've been talking about regarding the statements that Ms. Patterson gave to detectives on November 21st and then on November 22nd. This is the first statement.
Is that the officer you just said?
Yes.
What about that report do you want to question this witness about?
The report is not in order, so again, as I stated before, I would have to read it.
Mr. Brooks, I trust that you're prepared. These are your witnesses. So what?
you trust that he's prepared. Oh, ma'am, you're so sweet, but no. He's clearly not prepared.
Questions. What about that report do you want to question Ms. Patterson on?
Your Honor, I just stated 3 times I would have to read a little bit of this to form the questions.
Under my authority, under 90611, then, and given that this witness was initially called by the state, there was a full and fair opportunity for cross-examination by Mr. Brooks at that time, and they had ample time this morning to
Dismiss
question
her.
her. I will declare that his questioning of her to be closed. I will bring the witness out on the witness stand and then we'll bring the jury out, and then I will simply ask the state if there are any questions, and then we'll move on from there.
Just so I understand, what do you mean by closed?
I'm not allowing you.
She literally just explained it. Were you not listening?
And then we'll move on from there.
Just so I understand, what do you mean by closed?
I'm not allowing you to ask her any additional questions, given your full and fair opportunity that you had previously when she was called by the state, and given the opportunity you had this morning and your failure to identify for this court any probative and relevant information that she would testify to about what's in that report.
How do I, first of all, the report isn't even in order. So I would have to essentially read
It's your
at
report.
least some of it to even ask a
Mr. Brooks,
question.
this is your witness. I expect that you will be prepared and you will not cause delay by any lack thereof. So I'm bringing the witness out, the jury will come out, and you will not have another opportunity to ask any additional questions unless the state asks questions on cross-examination.
So what is we bringing the witness out for
I
then?
have
if
to do
can't-
that in front of the jury.
Man, I object to that ruling too. Can you give me a lawful law why?
Your objection is noted for the record. If you start interrupting.
A lawful law? You don't know shit about the law, Darrell Brooks. You should have taken your court-appointed lawyer and shut the fuck up and sit the fuck down. But no. This is what we're doing.
Interrupting me when the jury comes out or make any commentary, you will be removed to the other courtroom, and that's,
So I'm being held in contempt again?
no, it's not contempt, sir. It's a finding under Illinois versus Allen. It's a warning that you will forfeit your right
So I might
to
as
be
well
present.
I might as well have just
No
stayed
such
over there.
contempt finding.
I might as well have just stayed over there then if I.
I mean, if you would shut the fuck up. My God. this is my last little piece that I'm doing. I was gonna do the opening statement. Actually, I might still do that. Yeah, fuck it. Opening statement and then it's over. Cause my fucking head hurts.
Mr. Brooks, that decision is for you and you alone to make, and it is based on your conduct. If you're going to continue,
Just take me over there because I'm not finna get held in contempt for nothing.
I have not held you in contempt.
You did. You're attempting to hold me in contempt. That's what that is.
No, that's not.
You don't know what the fuck contempt is, and you've been trying to be held in it since the beginning of this trial. Are you gonna hold me in contempt? Are you gonna hold me in contempt? That's all you've been asking this whole time. That's what you want. Let's be honest.
So is it civil or criminal? Why am I being
Mr.
held in
Brooks?
contempt?
You're not.
I'm going to keep you in here because
that's the whole reason
you're
I
going to need
didn't
to
want to
call
come.
the next witness, and I'm going to need
Your
to
Honor.
bring you over in any event.
That's the whole reason why I didn't want to come over here because you was gonna find a reason to hold me in contempt.
Well, I'm finding a reason, and it's not contempt, but I'd find a reason to remove you based upon your disruptive outbursts.
Well, then remove me if
and
that's
your-
what you want to do. Remove me then.
I don't want to do it, sir. I
Obviously
want
you
in
do.
This courtroom.
Obviously you do. You brought it up before we can even get to.
No, because you've been arguing with her this entire time. Okay, we're done here. We're done with that. Okay, we're gonna find his opening statement because I'll be honest, it really pissed me the fuck off.
One instruction.
I don't like the fucking fact that they titled it this because sure it was emotional, but let's be honest, he didn't care about anyone but himself here.
Thank you, everyone. Please be seated. The defendant will now make an opening statement. The purpose of an opening statement is to give the defendant an opportunity to tell you what he expects the evidence will show so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. With that, go ahead, sir.
Obviously, I don't have any rehearsed or well prepared speech, so I'm just gonna speak from the heart. I would just like to first say that I want to bring to remembrance something I think everyone in this room has been taught pretty much as far back as we can remember, is that there's always two sides to every story. And for so long now, roughly a year, there's only truly been one side told of this story.
Yeah, the victim's story, because they're the ones who suffered. Whatever, keep going.
And I've sat back and watched from countless narratives that's been put out there, the way this incident has been portrayed at times, and finally everyone getting a chance to get the full story. You won't hear me try to argue facts.
That line fucks me up every time. Like, what do you mean? You're not gonna argue facts because the fact is you did it and you killed those people? You don't need to defend that, right? Got you.
Argue facts. The fact is that this incident was tragic. Very tragic. That's not lost on me. Facts are that there's still a lot of people healing, a lot of families healing, on both sides. And when I'm confident that the evidence will show, sorry, I'm getting a little emotional. When I'm confident that the evidence will show is that this incident was not planned. This incident was not intentional. And this incident was never even thought about.
You know, this kind of actually makes all of that worse. The fact that you didn't even think about it. Your impulsiveness is what drove you to drive that SUV through that crowd. And I'm fucking angry. I am. 'Cause now he's just gonna cry. And yeah.
It's easy to I'm sorry. Just need a second.
Okay. I will say, I appreciate that he is getting emotional here, but I don't think it's about the victims. I really don't. I think he's crying for himself.
I think it's easy to look at the magnitude of something like this and form opinions. I think it's easy to disregard a lot of factors. And I think in reference to what I stated earlier, it's easy to forget the other side of the coin.
It's not that it's easy to forget. It's you didn't lose anything. You didn't lose any family members. If anything, the reason you were doing this was in retaliation to your own family for whatever anger and whatever shit you were going through. And I think it's gross that we have to sit here and listen to you like get all emotional about it because you didn't care when you did it.
There's been a lot of suffering involved in this incident. A lot.
I believe you.
Obviously, with the families.
Yeah, the families of the people you killed. Mm-hmm.
With the community. And even the alleged defendant's family as well. There's been a lot of suffering.
The alleged defendant. Stop it. You're Darrell. Shut the fuck up.
a lot of misunderstanding.
What was the misunderstanding here? I don't know what you're referring to, but I don't think there were any misunderstandings here.
And I just want you to keep in mind everything that will be presented in its totality. Keep in mind. The power that you have.
I'm not gonna lie, this makes me angry. Seeing this when moments after, this is who he
Other
is.
questions, Your Honor?
As to this particular piece of
Just arguing, being a dick.
Discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr.
by
Brooks, I need to
something that
make
I
a
saw?
record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right, based upon the offer of proof provided by this.
This is who he actually is. So when I see him doing his opening statement for the jury and, tears coming down his face, oh, there's 2 sides. I don't care. I don't have any sympathy. I understand. But I don't feel bad.
State.
This is how you're treating people.
Prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would.
inaccurate, Your Honor. Can we have the prior counsel testify to that then?
Not
Because
at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit. That's
Mr.
why I
Brooks, I
raised the
presume, and you can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
It's you in the video, bro. They're trying to admit into evidence the video, the music video, with his SUV that he used to run over these victims in the background. So I understand why you're mad, but stop.
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified to, is in that video. That video is relevant for a number of different reasons, the first of which, it goes to identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, the evidence have, but you opened up the door for the state to show that video because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it because the still.
See, it's so funny. This never would have entered into evidence. This music video never would have entered into evidence if he had not challenged the witness on the stand. So isn't that hilarious? Isn't it hilarious how he gets so upset about evidence being brought in and asking about whether or not it's relevant or not when he's the one who opened the door? But he doesn't understand that. Because he's not a lawyer. So then he gets mad and thinks that it's a personal attack every time, like, oh, you guys are doing this to me. No, you did it. You did it.
Image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it
What do
relates
you
to
mean by
that.
it's no surprise to me that it exists? That was not the issue. The issue was how was it made an exhibit at the last moment? How does it be made an exhibit out of the blue?
It wasn't. He is not understanding. So, in court cases, lawyers have extra evidence that isn't necessarily part of their findings or what they're going to actually show in the court case. But what happens is sometimes you'll have the other side question to the point where you need to pull out some of those articles or some of those exhibits and use them so that you can further prove whatever it was that this person brought up. Like, if it wasn't for him bringing it up, the person's credibility, they wouldn't have had to pull out their backhand or their backlog folder. You know what I mean? But he's not understanding this. He's like, but what about the rule about having to admit things into court before they're shown? Well, in this case, the rules are a little different. Like in that situation, like they do have a certain amount of evidence that they can have that can be used at a later point if they're ever challenged. So that's just what he did.
That was the issue. The issue
State
didn't
can make an
have
offer of
anything to
proof
do
on
with.
that, because obviously they marked it as an exhibit.
But
They
with
had
all
it,
respect,
so go
Your
ahead,
Honor, you're
Attorney Hopper.
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was how does this, at the last minute, out of the blue, become an exhibit?
Attorney
That
Hopper,
was the
go
issue.
ahead and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection.
aware.
He said social
There's
media. He
nothing
didn't say
Hold
what it
on,
was.
sir. Stop interrupting. We have to
Please.
make a record of it. You've
Then make the record
interrupted multiple times. I've been abundantly patient
record
with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing at
asking me to be
me.
quiet?
Stop rolling your eyes at me.
Are you?
Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
No, this is a whole child, and we're gonna end it here because I have been triggered. Have a great day, guys. Peace.